Lawyers, what's the most obscure law that you've actually used in a case? A law professor of mine was representing someone who owned a goose and was being sued by a neighbor because the deed said no geese. When the deed was written, the singular and plural weren't interchangeable. Professor said deed only said no multiple geese and one goose was okay. Judge agreed. Judge was tired of hearing about a goose. One I heard from a criminal defense attorney in law school. His client is driving down a country road at night without any lights on. A police officer is parked off the side of the road and, seeing the man drive by, pulls out behind him to follow him but also doesn't turn on their headlights. Eventually they pull the man over and find that he has a lot of coke in the cab of his trunk. Charges are brought for possession with intent to distribute. They get to court, and the attorney cites the fact that, under the relevant state law, it is not legally required to have your headlights on at night unless there is another vehicle visible within 500 feet of your vehicle, because the police officer was also driving without headlights. The man had no reason to see them, and therefore he was legally allowed to drive without his headlights on. Because of this, there was no reason to have pulled the man over. Thus, the discovery of the coke was fruit of the poisonous tree. That is, any evidence that is discovered improperly must also be excluded. Case dismissed. Canada has an apology act stating saying sorry does not show responsibility or take blame for the situation you may or may not be at fault in. I can't see how that could be an aid in Canada. I haven't used it yet, but the other day while researching a related issue I stumbled across a 100-year-old case that said summons served on Sundays were null ab initio. Hasn't been overruled, although it's probably dead letter. If I ever have to dispute a summons that was served on a Sunday, I might pull it out and see how it goes. Not a lawyer, but one time I had to sue a landlord who made up some pretend reasons to keep my security deposit. I spent a Saturday in the law library at the local university and found a law that would let me win my lawsuit and claim triple damages. The landlord read my lawsuit and offered to give me my deposit back plus $500. Sweet. We have all like that in Hawaii. I cited it in a small claims court case. It didn't work. The landlord was so dishonest and shockingly unprepared that at the end, the judge just asked me how much they owed me and made that her ruling. I claimed treble damages because they were intentionally violating the law. She said the standard for that was higher than what I was presenting. I'm pretty sure I was right, but I'm not going to appeal a ruling in my favor, if that's even possible. I routinely cite a 1921 case regarding a forged railroad ticket when I'm trying to argue the best evidence rule of an original that's later been marked up with pen or has some notes on it. The case says that if something is printed out containing all the elements of what it's trying to do, then any handwriting on it is evidence that it's been altered, and the alterations must be shown to be lawful by whomever seeks to enter the item into evidence. Very good to use to keep things out of evidence. I didn't, but worked in an insurance litigation firm where a guy used an 1800s maritime law to defend a case that occurred on a boat on Lake Michigan. He wanted to get it out of state court and into federal court where civil verdicts actually have less value in our area. That was neat. My maritime law professor was a glorious asshole, and I'll never forget this story he told. For this, you need to know that below the mean high tide line on a beach is public access. My professor, in his younger days, had just finished the bar exam. He went to the beach. The beach was super overcrowded. Just a short walk down the shoreline was a private beach club. This beach and beach club were right near my college, so I've been there and seen both. The beach at the private beach club was wide open and much less crowded. So he walked down the shoreline and parked his chair somewhere below the mean high tide line. A few people from the beach club tried to get him to leave since he wasn't a member. But because he was in the public access section of the beach, legally they couldn't do anything. A client of mine was writing a scathing review of the Australian court system which he intended to publish in a book. When advising him regarding defamation etc., I ended up dredging up an old Australian law of scandalizing the courts whereby a person commits an offence if they incite disenchantment or distrust to the extent that it undermines public confidence in the judicial system. Wow, that's some 1984 shit. How on earth are you to spur any change in the courts if you're not allowed to be publicly critical of it? Well, it's more 1894 than 1984, but I get your point. I had to give advice to a public entity about the US flag code. An employee had raised a grievance that the way the flag was hung in a particular room violated the code. Technically, the employee was right. The question was what kind of remedy was enforceable under the flag code for a violation. The answer, none. Petty. Upset employee got no satisfaction. Work for a debt collection law firm, and we also do some subrogation work. State of Michigan has a law on the books from back in the day whereby cattle are exempt from liability in automobile accidents. Case involved an accident due to the cattle going across the road pretty suddenly and there was a car-on-cattle collision. Guess who got blindsided in court by this law from the 1800s? Obligatory now. But I work at a lawyer's office in Germany. One of our lawyers managed to get our client off a speeding ticket by finding out whether or not you needed some sort of specific certificate to be allowed to operate the radar speeding gun. He found out there indeed was some obscure certification, of many, that is needed and is supposed to be renewed every 2 years or so. The officers who wrote the speeding ticket hadn't renewed theirs in a while. Apparently nobody did. Though, nobody even really knew about that specific certificate. He won the case. The judge agreed they shouldn't have been operating the radar gun without the certification. Even though the dude really was speeding. I cited a 1500s case from the UK on grab-a-rubbing that stated that property can never be ownerless in a dispute over the ownership of a pile of dirt. I also cited a 1700s case on interpreting the rule against perpetuities. Car sales tax case. Client has to post amount of disputed tax and then ask for the money back before getting an opportunity to sue to get money. There are also interest and penalties. If you do not send a letter asking for the state to not pursue, state can still go after client even though case is pending. On the letter to request the state not pursue, at the top must be written in red ink specific words or the state can ignore the letter per the regulation. This case has been going on since 2006 and haven't been able to file a case yet in court. Also, state never actually has to respond to the request for a fund. I do remember hearing a story where this guy in Michigan was arrested for underage drinking, but was only a couple of months away from turning 21. He went to court and pulled out an abortion law for Michigan stating that life begins at conception. So when he asked the judge if this law was still valid, which it was, he then stated that since that was the case, he was technically over 21 years of age and legal to drink. The case was dismissed. And when the prosecutor made a stink about it, the guy said, "Hey, it's your rules, dart." When I was in college, a girl who worked at an expensive law firm told me this and I always wondered if it was true. She said that when Oklahoma passed a new drunk driving law that they specifically mentioned the breathalyzer as a machine that the cops had to use, and since it was a new one most places didn't have it. So if you got a DUI and they didn't use that machine or even owned old ones, you could get it dismissed by saying they weren't compliant with the law and used or could have used the old ones. She said they had gotten cases dismissed using that argument. Not exactly a law. But if there's a no-deal Brexit, all kind of old treaties between European countries and the UK kick in. I know some countries are already proactively retracting old treaties to prevent weird or unwanted stuff from happening. Can give sources but can't find them in English this fast. To make things more complicated, French, Belgian and Dutch fishermen have a lot of boats under UK flag and using UK fishing quota permits as those were easier to get some time ago. But in practice they sell their fish on the continental market. How will this hold legally after Brexit? Depends on which old treaties are still active. I found one beautiful example already. Belgians can fish in British waters thanks to 1666 charter. Now. But in the 60s, my hippie brother was busted for a traffic infraction in Hingham, Massachusetts. While being patted down, he farted in the cop's face. He was charged with a colonial-era law, uttering in public, and fined. I miss him. When I was 13, I was arrested in Portland for spitting. Apparently, somewhere in their oldest law book, spitting on the bricks was against the law. And they went with it. Handcuffed. Thrown in a car with lights and sirens. I was booked at the station. I could hear my mom screaming at everyone she talked to, armed or not, about how ducking stupid they were. It was one of the only times I felt like my mom had my back. They dropped the case when she started offering interviews to the local news stations. But I still hold on to my citation for a good laugh. This was 19 years ago. For reference. Not a lawyer, but know of a weird law for hunting. You are not allowed to claim deer roadkill if you are not up to date on your child support payments.